Yes, hello. Great to be here. Thank you for the invitation. It's an honor to be here at my first GeoNet OpenForum. My name is Jørgen, and I'm a lawyer working for IOM Law, which is a very small, very niche, very specialized law firm based in Norway and Australia. We focus primarily or exclusively on CCS and carbon management in general. We are a small team of 7 members, growing steadily, but it's highly specialized, and this is what we do. It's more of a consultancy kind of law firm where we help work with mostly EU member states, but also non-EU member states and companies, energy firms on ensuring sound CCS regulation and contracts. I can speak louder, yes. I will touch upon 4 things, and I've also been too ambitious in the number of slides, so we'll see how it goes, but I will do my best. I will touch upon regulatory developments around the world, and identify some common regulatory features that we have seen in our work on different continents. I will try to touch upon some takeaways for how to accelerate CCS in Europe based on these common regulatory features, and then, if there is time, and I think there will be, I have a case study from an EU member state where we're currently working quite closely with them and their ministry. So, as we've heard, CCS development is accelerating rapidly across the world, in Europe, but also in Africa and Asia. And regulatory developments are happening at the same time. It's not just, it comes together, of course, but we see both pre-deployment regulatory developments, meaning before any projects are launched, you develop some kind of legal framework, but we also see post or mid-initial deployment adjustments. For instance, in Norway, who's had a first wave of deployment, then testing of the legal frameworks, testing of the procedures, and then the regulators have tried to take some of the experience into account and adjust the legal framework where necessary, which has been necessary, because you can't preempt everything that will happen in terms of procedures and then different potential issues in the regulatory framework. But despite the differences in legal frameworks and legal traditions, in levels of government, types of government even, including social and environmental considerations, the main legal structures for how to do CCS are basically the same if we are in a big oil dependent country in Africa, or if we're in Norway. The main structures for how to do CCS from a regulatory perspective at least are quite similar, or they have chosen for it to be similar. And in our work, we have identified quite a number of common regulatory features for how to not just deploy CCS, but how to do it effectively, or how to do it in a financially sound, regulatorily sound, democratic way. And I will be presenting some of these today. And the purpose is not to do groundbreaking legal research, but just to develop some kind of terminology and a common understanding for what a deployment-ready framework is. And we're talking about features, meaning general features, not necessarily specific mechanisms, which will have to take into account the specific needs and political situations and legal situation of the country we're in. Some countries are less democratic, have less strong institutions, they will have less or no public involvement, or not actual public involvement, or they will have different requirements in terms of financial security instruments, which, because of historical issues with certain financial instruments, they will not constitutionally, for instance, be allowed to use them. So that has to be taken into account. And in the EU context, the purpose of these features are not to replace the CCS directive. It's made basically to bring in real-life experience into the transposition of the directive. So you have the directive, which is it's good and complete, and then you can kind of supplement it with tested and tried and not so good experiences from different countries and different deployments or partial deployments. So it's a long list. I won't read all of it, but I have 2 slides on this. But we have seen across the world that there is a need for clear rules on who can use land surface and underground pore space to build and operate CCS infrastructure. We also need clear criteria and rules for identifying safe areas for geological storage, including mapping of formations, geology, and environment. We also see that most countries have, or all of them have, some kind of field development plan requirements, which includes more or less a monitoring plan, emergency response plans, EIAs, etc. EIA in general, as mentioned, it's important and should be conducted always at the project level, and most countries also at the strategic level, so meaning planning level, broader government plans for different areas or different policies. The polluter pays principle should be the basis for a life cycle regime of strict liability. And financial security, then there are the differences between the different instruments that can be used, of course, but some type of financial security must be maintained throughout the life cycle of the project. Number 6, clear evidence and procedural requirements for the transfer of long-term liability and stewardship from the operator or operators to the government must be enacted. And number 7, a requirement to ensure meaningful public participation, including access to information, for instance, which is in Europe it's mandatory, but in other countries it's not necessarily customary. And I've emphasized meaningful here to not just have it as a formal requirement to tick a box, but to actually try to have a meaningful public engagement. Number 8, to establish clear definitions and rules regarding the ownership and the title of CO2, including liability across the value chain and where the liability shifts between different value chain operators or owners of CO2 or infrastructure, and to have it spelled out quite clear, either directly in the regulations or to allow for contractual, to deal with it contractually later on. Number 9, to preemptively address CO2 storage conflict with other subsurface or surface resources. So drinking water and CCS, for instance, what if there's a conflict between the resources, how to deal with it and how to prioritize if necessary. Number 10, if relevant and if the country chooses to go down the EOR route, to establish clear rules for the recognition of EOR, enhanced oil recovery. In Europe, it's the CCS and the ETS directives and the MRV regulation, but also rules for transitioning from EOR to permanent geological storage. Number 11, as was mentioned earlier, enact rules for cross-border storage and transport, plus a legal basis for operator-level contracts. So when you do cross-border cooperation, you will most likely need intergovernmental agreements between governments on Paris agreements accounting, for instance, on liability, on accidents, aligning permitting flows, but also the operators who actually do something on the ground or underground will need to cooperate and have contracts. But those contracts will most likely in most countries need an intergovernmental agreement, a government contract to authorize it, basically. Number 12, ensure third-party access to transport and infrastructure. And number 13, avoiding unintended classification of CO2 as waste, which is a hot legal topic, not very important for everyone, but not super sexy for most people. But it's basically avoiding that CO2, which can be waste and should be classified as waste sometimes, that it's not unintentionally classified as waste. And then waste law, which is very, very, very technical and very burdensome and very lots of procedures attached to it. If CO2 is unintentionally classified as waste, you will have to do export bans, for instance, and different forms and different regulations and a whole new regime of law that applies. So to avoid that happening unintentionally. Yes, and we are currently working in an EU member state which has transposed the CCS directive. Everything is formally in place. Everything looks good on the books, so to say. But we have cooperated with them, our law firm, and a broader consultancy to assess if their legal framework is deployment ready. Can this, which is a technically correct transposition of the directive, actually be used? Can it be effectively deployed, or CCS be effectively deployed, and will it be competitive in the region, where we see more CCS activity? And the answer was no. And the answer was no, but you don't need to do big changes, but you need minor tweaks, adjustments, so to say, based on our experiences in different countries and the common regulatory features, and to try to bring in lessons learned in other countries to this country before they actually start deploying or trying to deploy anything. And we formulated a lot of recommendations, but these are just some to show what kind of recommendations that we came up with, and try to make their potential future CCS deployment both effective and regionally competitive and financially sound. The recommendations are about ensuring permitting or streamlining permitting procedures, ensuring NCA compliance, ensuring a simple and regionally competitive CCUS fee structure. So when they transpose the CCS directive, their fee structure, it contains 4 different fees across the CCS value chain that are exceptionally high and exceptionally technical and exceptionally difficult for operators or investors to understand how it works, while none of the other countries in the same region apply any type of fee like this. So our recommendation was to not bring in less money to the government necessarily, but more about trying to have one fee or find different cost-setting models through state ownership, for instance, rather than having very heavy, burdensome fee structures that could scare away investors. Yes, balance financial security, flexibility in approved instruments, clarify CO2 legal status, as I mentioned, the importance of what is CO2, who is responsible under the ETS directive, but also integrating established technical and ISO-aligned standards into regulation soft law, so to use the best practice and the best available technical guidelines that exist globally, sometimes, usually, into regulations and law where appropriate. Of course, all countries don't allow for this or don't have a culture for this, but to try to integrate it as much as possible. And number 6, use demonstration projects as catalysts for regulatory development and CCS deployment. So, as I mentioned, a legal framework, you can predict everything that will go wrong or that will not work or that will be all the rules how they will apply. So by having, as the CCS directive allows for, a smaller demonstration project for research purposes or testing the system, so to say, before going full scale, is we've seen in different countries, especially Norway, of course, or Italy with a phased deployment is a better approach for testing the legal system and the framework and the procedures before going crazy and full scale. Yes, so 4 bullet points on takeaways for accelerating CCS in Europe. As I mentioned, legal text can be advanced and well formulated, but post-deployment or trial changes will be needed. I can't think of any country or any field of law really where you can create a perfectly sound and functional legal framework immediately. And we see now that the second movers in Europe, in the Baltic countries, in different parts of Europe, have been watching the first movers, Norway, Denmark, the UK, for a while, and seeing how their legal systems and regulatory frameworks have developed, and then trying to learn from them, and both for good and bad. And the second movers are now entering the game and really learning from and trying to copy or not copy where needed the first movers. And for Europe or in the EU context, the common regulatory features are best practice and for how to operationalize the respectful transpositions of the directive. Yes, and finally, as also mentioned earlier today, and on one of the posters outside, public participation and stakeholder engagement, meaningful is very important, and we see that in different countries. And if you don't have the so-called social license, as I saw in the title of one of the presentations for tomorrow, which is a great concept, I think, social license for CCS, you probably will fail, or you will have a lot of public resistance, which is something that can, also from a regulatory perspective, understood normatively, but to try to integrate it into your frameworks, the law itself, as much as possible, to a certain degree, of course. How am I on time? Ooh, okay, I have 1 minute. Well, all of this, we have received funding from the Norwegian government to write a book, basically, on this, a handbook on development of CCS regulatory developments, where we will map and compare different legal systems and regimes and drawing on our own experiences and also other experiences, while bringing in the legislative, regulatory, but also the more practical, technological aspects as well. We haven't started yet, so this is just to brace yourselves for next year. Yeah, that's it. Thank you very much.